This is a lecture from OpenTuition. To benefit from the lecture, you should download the free lecture notes from opentuition.com.
Okay, we're up to the memorandum and the constitution of a company. Just indulge me for a moment, Julie, because it says here, historically, the memorandum of association was a major document. It wasn't just a major document, it was the major document. It was supreme above the articles of association. They were always talked of as a single document, the memorandum and articles of association. But if the two were in conflict, the memorandum prevailed. The memorandum was the one that was followed where there was a conflict between these two elements of the Constitution, the memorandum and the articles. However, in 2006, that system was radically changed. And so now the memorandum is just a document of record. And it simply records the fact that we, the subscribers, I'll tell you what a subscriber is in a minute, we, the subscribers, wish to form ourselves into a company. We wish to form a company, we agree to become the members, and we agree to take at least one share each. The word subscribers, it's Old English really. The verb scribe is an old way of saying to write. And a scribe was a person who could write or was a writer. And sub, as you know, is the prefix which means under, as in submarine. So a subscriber is a person who signs his name at the bottom of a document. He scribes sub underneath the document, and it's at the foot of that document that the subscriber signs their signature, and that formalizes this memorandum. However, the memorandum is just a document of record. It's of no great significance these days. It used to be, but it no longer is. The company constitution now, the company constitution used to be the memorandum of association and the articles of association. That used to be combined the Constitution, but that has now changed, and the Constitution is now simply the Articles of Association as amended by any resolutions or any agreements that affect the articles. So when anyone now mentions the word Constitution, they're talking purely about the Articles of Association together with any resolutions that affect those articles, any agreements, any outside agreements that affect those articles. So now we need to consider articles. And there's two questions involved with articles. There are two major elements. Articles are prevalent throughout company law, English company law. A company may do this so long as the articles allow. The directors will do that so long as the articles allow. So throughout every mini topic of articles, of company law, the articles have an impact. So the two major areas about the articles about which we are concerned are, first of all, the contractual force of those articles, and secondly, when we get there, the alterability of the articles. So the contractual force, first of all, where a person becomes a member of a company, it is as though they have separately entered into a contract, not only with the company, but also with every other individual member. Just let me show that graphically. There's the company, and there are you, and there's me, and there's John Moffat, and Ken, and Chris, and I forgot, I mustn't forget Colin. And it's as though when you and I and these sorts of, when we become a member, that is when our name appears within the register of members. Doesn't matter whether normally we would hold shares to become a member, but it is potentially available to be a member and not hold any shares. But that's a tiny, tiny point. So when we acquired our shares and our name is now registered in the register of members, It is as though you have entered into a contract with the company, but you've also entered into a contract with me and with John and with Ken and with Chris and with Colin. And I also have entered into a contract with the company and with John and with Ken and with Chris and with Colin. And so John has entered into, and Ken has entered, and it's like this. And how complicated is that when you're talking about multinational quoted organizations with thousands of members, each of them entering, it is as though they have separately entered into a contract with each and every other separate member. Amazing if you think of it, just conceptualize those number of contracts if you can, when you have a moment. Okay, so that's the position, that's the situation. It is as though they've entered into a contract with it and with all the other members individually. The terms of that contract are the terms that are contained within the articles. So if there is potentially, I suppose, a dispute between members within a company, then we need to look at the articles of the company in order to help us to resolve that dispute. Well, it would be most unusual, wouldn't it? You wouldn't normally expect, as a shareholder of what's the telephone company? British Telecom. As a shareholder of British Telecom, for instance, you wouldn't expect to have arguments as a shareholder with other shareholders of British Telecom. It just doesn't make sense. The terms of the contract, therefore, contained within the articles. And the effect is to bind the members to the company. It binds the members to the company, and it binds the company to the members, and it binds the members to each other. Inter se qua members is the Latin expression. So it's no good you as a member trying to avoid this contract, which is contained within the articles, when you're in dispute with the company. And it's no good as the company trying to avoid its contractual obligations with you as a member. And equally, because you're in contract with me and with John and with Ken and with Chris and with Colin, because you're in contract, it's no good you trying to avoid the provisions of those articles as well. The members to the company, that was the case Hickman and Cantor Romney Marsh Sheep Breeders Association. I keep being asked. It's a recurrent question. I read another one just this morning, actually, on the general forum. It says, do we have to remember all the case names? You don't have to remember these case names. You don't have to remember the dates of the cases. You don't even have to remember the facts of the cases. It is vitally important that you remember the principle of law that was established or that was confirmed by those cases. But the actual names and the details, no, there's no marks for it. There's no opportunity for you to get that detail, that knowledge into a multi-choice exam. So I'm not even going to tell you about Hickman and Cantor Romney. It's an interesting case. If you want to look it up, you can do so by looking it up on the internet. But otherwise, let's move on. Equally, the binding the company to the members, and so the company has to obey the terms of the articles. That you'll find in the case Pender and Lushington. And again, I'm not going to go into that detail. I will do with one or two cases, just because they're a bit of fun. But Pender and Lushington, no, there's no need for us to consider that. It binds the members to the company. Pender and Lushington, it binds the company to the members. And it binds the members to the members. And that's the case, to illustrate it, that's the case Clark and Dunraven. Now, what's happened to my pen? Why is I'm not writing? Oh, dear. So the case Clark and Dunraven, again, I'm not going to go into the details of it. It's an interesting case, but I'm not going to tell you about it. Just simply remember, it binds the members to the members. But the articles do not create a contract between the company and an outsider in an outside capacity. So even though the person may be a member of the company, the articles don't create a contract between that person in their other capacity, not in their capacity as a member, but in the case Ely and Positive Government Life, it was in his capacity as the company solicitor. Ely, I'll tell you the story of this. Ely was involved in the formation and creation. It was the promoter of the company, Positive Government Life Assurance Company. And within the articles it said, and it was quite right, that Ely should be a member. Fine, he owned some shares, his name was in the register of members, but that Ely should be appointed as the company's solicitor for life, or until Ely decided he'd had enough. After a few years, the other members decided that they didn't want to use Ely anymore as the company's solicitor, so they changed, and Ely said, you can't do that, you can't do that. It says in the articles that I shall be the company's solicitor for life, or until I decide I've had enough. And so he sued. And the court said, well, yeah, but the articles are only a contract between the company and the members. And he said, well, I am a member. And the court said, yeah, but you're not suing in your capacity as a member. You're suing in your capacity as the company's solicitor. And he said, well, yes, I am, but I have a contract with the company through the articles. The court said, no, the contract is between the company and its members in their capacity as members, and not in any other capacity, but in the capacity as members. What harm have you suffered, Ely, as a member of the company? And Ely said, well, they've got rid of me as their solicitor. No. That's the harm that you've suffered as a solicitor. What harm have you suffered as a member? Well, they got rid of me as a solicitor. No, listen. What harm have you suffered as a member? None. Therefore, you can't sue. You can't win. You can sue, but you will lose. You can't win the case because the articles are a binding contract between the company and its members in their capacity as members and not in any other capacity. I'm going to carry on messing around with this pen to see if I can get it to work, but it doesn't look like I can. So I shall carry on talking, and you'll just have to watch the screen for this thing moving backwards and forwards. It looks like I've lost the ability now to move the screen. There we go. Are we ready? I think so. That's alterability. We don't want that yet. There we are. Easily and Positive Government Life. And again, my pen still isn't working. I wonder if I click this up here. It's still not working, unfortunately. I'm so sorry about this. Okay, we'll move on anyway. It's not a big issue, I don't suppose. I think we've gone too far there. Name change, and these are names, alteration, alterability. Right, here we go again. Let's try it again. Alterability. I said there were two topics within articles. The first one is the contractual force of the articles. The second one is the alterability of the articles. And there's a basic rule here that says the articles may be altered, but may only be altered if it's for the benefit of the company as a whole. The alteration must be for the benefit of the company as a whole. Now, the question arises, who or what is the benefit of the company as a whole? Well, the company as a whole is a separate entity, but as a whole, it doesn't exist, does it? It doesn't exist without members. So when we're talking about the company as a whole, we're talking about the aggregation of all the members of the company. So it's for the benefit of the non-human individual called the company itself, but also for the aggregation of the members that represent that company. So it can only be altered if it's for the benefit of the company as a whole. But who is that company as a whole? Well, clearly it's the members of the company, the aggregation of these members. But which members? The members that created the company, the members that were people that were members last year or the year before? Or are we just talking about the current membership, the people who own the shares and have their name registered as at the date of this proposed alteration. No, we're actually going further than that. We're looking beyond that. We're looking at the future individual hypothetical member, the court said, the individual hypothetical member of the future, at whose feet the blame for English law is laid. So it's not just you and me today, but when you sell your shares and when I die and my shares are passed on to my heirs, then they are also to be considered, even though we don't know their identity. They are the people that we must bear in mind, so that when we're proposing an alteration, it shall be for the benefit of all these individual hypothetical members of the future. Again, I'm not going to talk about these individual cases, Greenhouse, Shenardo and Cinemas. I don't see there's any need for you. The basic principle is the one you must remember, that the alteration must be for the benefit of the company as a whole. No outside contract shall prevent a change, but the company may become liable for breach of that contract. Southern Founders and Sherlaw was appointed as the director and was on a contract to serve as chief executive officer. But then when they removed him, he was appointed as a director. When they removed him as a director, it was no longer appropriate that he should continue as the chief executive officer. So the alteration of the articles to remove him was then in conflict with the fact that he had a separate contract as chief executive. So no outside contract shall prevent a change. Yeah, okay, you can alter it and remove the provision that says that Sherlaw should be the chief executive officer for life. But if he's also got a separate contract, then you're facing the prospect of having to compensate him for that breach of contract. Even if the proposed alteration adversely affects only one. The case Allen and Goldreefs of West Africa, the alteration was to enable the company to freeze the rights of shareholders who separately owed the company money. And there was only one shareholder who separately owed the company money, and that was Allen. So when Goldreefs of West Africa sought to alter the articles to give them this freezing opportunity, Allen said, hey, that's not fair. That's directed at me. I'm the only one here that owes the company money. And the court said, well, yeah, but even though it's only directed at you, it shall be for the benefit of the company as a whole. The individual hypothetical aggregation of members in the future will likely benefit, because anyone that owes the company money and is refusing to pay, well, then the company has power over that person's shares. And so the court allowed that alteration to go through. But alterations allowing the compulsory purchase, the compulsory removal of a shareholder, that's unlikely. It's more likely than not that the court will disapprove of that one. Let's see if I can. There we go. We have the case Daffin Tinplate, and the company's Llanelli Steel. And Daffin Tinplate was again a situation like this. All these companies created the company Llanelli Steel, the steel rolling mill. So all these steel companies in the area said, well, let's get all our steel produced by Llanelli Steel, the central hub. And then at the end of the year, what we can do is we can share the profits out amongst us. Well, that was great until Daffin Steel started sending its business to another steel rolling mill called Baineer. Don't worry about the names. Don't worry about the story. It's just an interesting story. So these others, seeing what was happening in the Daffin Tinplate, even though they was a member, 8% he owned, even though they were a member, they said, well, let's alter these articles so that if it's approved by a majority of not less than 90%, then that majority shall be able to buy out, compulsorily purchase the shares of this dissenting minority. And Daffin said, well, you can't do that. That's not acceptable. That's not allowed. Just imagine if that had been allowed. Let's imagine that we've got shareholdings here, 20, 12, 30, whatever. and that we'd allowed Daffin to be bought out, and so that 8 therefore went there. These people then turn around and round and round, and eventually that one will be bought out, and then that one will be bought out, and then you finish it. If you allowed that sort of thing to happen, the logical progression of it would be that the rich and powerful would be able to buy out the small and not so powerful, and that would be unfair. So Daffin Template successfully fought against that alteration. But when we have a defrauding director, this case Shuttleworth and Cox, clearly in that case, one of the directors was defrauding the company. You alter the articles in order to allow the majority to get rid of this defrauding director. And same with this one, the competing members, the expulsion of a competing member. That's interesting because this is something a 1923 case. Date's not important. Something a 1923 case. And it was believed, I suppose, in those days that if you were a member of a company, you were privy to privileged information about that company. And therefore it was unfair. You're getting an unfair advantage when you set up a competing business because you know what this company, where you're a member, you know what they're doing. And so you set up in a competition, and that would be unfair. So they allowed the alteration to remove a competing member. I don't think, and nor did textbooks, not just me, I don't think that decision will be found the same today, because membership of a company does not entitle you or enable you particularly to get privileged information about the activities of the company. In this time of relative openness, all the information is there within the company's financial statements, so it's unlikely that that decision will be the same. It's possible to prevent alteration by weighted voting rights. Now, I will tell you about Bushell and Faith because I find it amusing. Bushell and Faith was a father, and he's got 3 children, a daughter, and a son. And he left 100 shares in the company. There were only 300 shares altogether. He left 100 shares to each of these 3 children when he died. And within the articles, it said that in the event, these 3 were shareholder directors, in the event that any one of these should be proposed for removal, a compulsory purchase, should be proposed for removal as a director, that person's shares shall carry 3 times their normal voting power. So daughter 1 and daughter 2 got together and said, let's get rid of little brother. And so they did. They proposed an alteration. They proposed a resolution to remove the son, and they added up the votes in favour of removal. It was 200, and the votes against was the son voted 100. But of course, his votes were worth 3 times as many. So for the purposes of that one resolution, the son defeated that resolution and was able to prevent himself from being removed as a director. And of course, then when daughter 1 and the son get together to remove daughter 2, again, it's 200 in favour and 100 times 3 voted against. So daughter 2 protected her status. So I think that's a cunning move by the father. I think that's very clever. We move on now for the procedure for alteration. I think this is the first time we've come across special resolutions. Now, there are a number of specials within company law. The special resolutions, which there is a separate chapter on meetings and resolutions. So I will very quickly, during articles, I'll very quickly look at special resolutions. But this is not to be confused with, that does not equal special notice. It does not equal special manager, and it does not equal special business. These are 3 other specials within company law, within English company law, which is not only obviously part of the English variant for F4, but it's also part of the global variant for F4. So special resolutions is not the same as these other 3 specials. What a special resolution is it's required for, I think it's about 36 different resolutions of company members where we need a particular majority to get that resolution passed, and the majority is 75%. If it's not a special resolution, it's an ordinary resolution, and an ordinary resolution is just more than 50%. It could be 8,632,467 and voting for, and it could be 8,632,466 voting against. And if that's what this measured, then the resolution is passed if it's an ordinary resolution. But if it's a special resolution, then it needs a 75% majority of the votes cast by those members who do vote. Those members present in person or by proxy, and who are entitled to vote and who do vote in favour of the resolution. We'll look more closely at that when we look at meetings and resolutions when we get to that chapter. But it's not just a 75% majority requirement, it's also 14 days notice. It is available for companies to have general meetings of members with less than the statutory notice period. It is available for that to happen. Private companies, you and I are the only members of a private company. We can have a meeting just like that now, if you want. And if it's a private company or a public company and I'm the only member, then I can have a meeting whenever I want. I can be cooking my dinner and decide to have a meeting. I could be just first thing in the morning waking up and decide to have a meeting. So it is available for both public and private companies to hold general meetings of general meetings of members with less than the statutory notice requirement. But if we need a special resolution to be passed, then 14 days notice normally will be the requirement. If we've agreed to short notice of the general meeting, then 14-day requirement is dispensed with. Once the resolution has been passed, and only if it's been passed, a copy of that resolution will go to the registrar within 15 days, together with a copy of the amended articles. And this will go to the registrar. Remember, the registrar of companies, this person at the moment in Cardiff, if it's an England and Wales company, the registrar of companies, or in Edinburgh, if it's a Scottish company, if it's registered in Scotland, or Belfast if it's registered in Northern Ireland. The alteration is binding on all members, so even though you didn't approve, even though you didn't vote in favour, and maybe even if you voted against, if you were one of these people not part of the 75% voting in favour, you don't approve of the resolution. So it's binding, that resolution is binding, but it may be the case that you can object, or it is the case that if you're of the appropriate percentage or the appropriate number, then you may object to the court against that resolution which has been apparently passed. The articles may say that for a meeting proposing an alteration, it may be Allen and Goldreef's that the resolution will only be valid if the affected member is present at the meeting. So Allen and Goldreef's, if that had been the case in the Allen and Goldreef's situation, then Allen could have prevented that alteration simply by not attending. The articles may require a greater majority than 75. Yeah, maybe. If it says within the articles that any proposed alteration shall be approved by a majority not less than 90%, then the articles obey. But you cannot set up a situation where the articles are unalterable ever, where no matter how many people vote in favour, this provision shall not be altered. A bit like Obamacare. That when Obama has introduced Obamacare into the United States, and now Trump comes along and says, right, we're going to get rid of that. Now, if it had been possible, Obamacare could have been entrenched within United States law, and it would not then have been possible for Trump to get rid of it. So that's the situation that we're looking at. It's not possible to put something so deep into the Constitution that it's not capable of alteration. Now, it's not doing it again, is it? It's not playing right by me. There we are, we've done that bit. Company names. I think probably what we'll do is we'll start with company names on the next lecture. So I'm going to stop there and we'll move on to company names.